Welcome to the Brigham Young University Family History Library webinar series. Thank you for joining us today. My name is Braden Knutson, and I'll be your host for this webinar. We'd like to remind everyone that these webinars are being recorded, so you can come back and watch them later if you missed something or you just want to rewatch it. I encourage you to answer some of our polls we've got at the bottom of the screen. Let us know where you heard about the webinar and where you're listening from. And as you're doing that, we'll go through some of the announcements for today. If you haven't heard yet, we've gone over this a few times, but our Family History Consultant Training page is now active and available on the BYU Family History Library website, and there is a URL that shows where that can be found at. And coming soon, we're working on currently our January schedule of webinars, so keep an eye on our website so you can see when that gets posted, and we'll send out emails and notifications on our social media sites as well. And we'd like to wish everyone a Merry Christmas and a Happy New Year going forward. This is our last webinar of the year, so it'll be the last time get to hear from us. So today we'll be pleased to hear from James Tanner, who will be giving a presentation titled Privacy Concerns and Genealogy. James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law at Arizona State University. He served for 2 years as an intelligence analyst for the U.S. Army and 39 years as an Arizona trial attorney. He has previously owned a retail computer business and an Apple Macintosh software company. James has over 32 years experience in genealogical research and is an avid blogger of Genealogy Star blog and Rejoice and Be Exceeding Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Church Library and is currently serving at the BYU Family History Library. He has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren. So we'll get this, James, now and remind everyone about our comments box and also our questions box. If you have any questions during the presentation, feel free to write those in and we'll make sure that they're all answered by the end.
Howdy, this is James Tanner, and welcome to another BYU Family History Library webinar. We remind everybody, as Braden has just said, that these webinars are recorded and uploaded to our BYU Family History Library YouTube channel, where you can subscribe and receive notification of our uploaded videos. We now have in excess of 200 videos up, and we'd invite you to view them. We're going to talk today about privacy concerns and genealogy. This is a subject that comes up very, very frequently, and usually in the context of discussions about what you should and should not put online, what you should include in a family tree, whether or not living people are properly included in an online family tree, and all sorts of other issues like that. And unfortunately, there are a substantial number of people out there that are so concerned about privacy for a lot of reasons, some of which are valid and some of which are totally generated by media hype, that they will not put any of their information online. In other words, they keep their genealogy on paper and say, and because they're afraid that someone's going to steal their identity or do some other terrible thing if they put anything at all online. As we start out this, we have to realize, of course, that there are risks in everything that we do. It's risky here in Utah Valley driving down from my home to the BYU, believe me. And there are some other things that are risks, and we have to make our judgments based on a valid assessment of the risk factors involved. So let's kind of look at what privacy is and what privacy may not be in our present society. First of all, here's a general rule of privacy. Privacy is essentially a complex system based on social and cultural expectations and mores, or mores, if some people say it. When we talk about this, we understand that what we consider to be private is sometimes considerably different than what is private in other countries. If you've had an opportunity to travel outside of the United States, you may have realized that your concept of privacy does not necessarily correspond to what happens in Europe or in other countries, Central and South America, for example. The way that people live in the countries of the different countries around the world, that during one period of our lives, we were living in the country of Panama in Central America, and there was a part of Panama City called the Marañón, which had an average occupancy of 50 people per room. And you can imagine what if the term privacy probably had no concept in that particular society. What we would consider to be private things were things that were never private in that kind of a society. So what we're really looking at here is what you or I have been essentially preconditioned by our background to expect as privacy. And I might suggest that with the extremely rapid advance of technology today, where over half of the world's population presently has access to mobile phones, that the concept of privacy that we've had in the past is becoming altered very rapidly. So what else is privacy? Let's kind of explore some other issues and some of the other aspects of it. This is a technical definition of it. Privacy is the ability of an individual or group to seclude themselves or information about themselves and thereby express themselves selectively. Okay, so what we can do consider the word seclude there means that it's like seclusion. In other words, it says that you can prevent other people from knowing certain aspects of your life or the life of your group, meaning your family or your greater group, and those things are considered to be private. And they can also avoid saying certain things. We recognize certain different types in the law, for example, we represent certain kind of privileges. We call it privileged communication. We have a doctor-patient privilege. We have a lawyer-client privilege. We have a minister or religious representative to the parishioners, what we call a parishioner privilege. That means that in certain circumstances, communications made between those individuals are not discoverable or admissible in court. In other words, you can't force an attorney to disclose a privileged communication from a client. If an attorney discloses that information, they could be liable for breach of their ethical duty as an attorney. Now, the question that would be raised here in this context is, what does this have to do with privacy? All of these things are different aspects of the concept that we call privacy, because privacy is essentially, as it says here, the right to limit communication about certain aspects of a person's life or his family life or group life. And for example, religious organizations and social fraternal organizations have things that they consider to be private or secret. Sometimes they call those things secrecy, but those are the kinds of things that may or may not be reflected in the general society as private. Okay, and what else is privacy? We have some more definitions of privacy. This one has the point that privacy is almost varies from person to person. So if you ask one person what they consider to be private and another person what they consider to be private, you probably are going to come up with variations. And of course, as I've mentioned already, those variations are much greater across cultural and social barriers than they are within a social barrier. So if you live in a smaller town and you live in a very small community, what is and what is not considered private may be far different than if you live in a very large town, one of the great metropolitan areas of the country. People in a larger metropolitan area can maintain their privacy, if you will, much easier than you can if you're living with the same people every day and see them at the store and see them at church and see them in the restaurants, and every place you go you see the same people. Very, very, very soon you find out that there is no real privacy in that type of situation. Another thing that's important to recognize is that privacy is not security. We're not talking here about whether you're secure in your person and your property. We're talking here about information that may or may not be transmitted to others with or without your permission or understanding. And it's in our society, privacy is considered usually to be the right to be let alone and free from interference or intrusion. Um, to the extent that these occur, we feel that our privacy has been violated. But on the other hand, if we disclose the information voluntarily or semi-voluntarily, that we're not considered that to be, we don't consider that to be a breach of our privacy. And all you have to really do to see how this particular point works is to go on to any social networking website such as Facebook and look from through the different posts. And in some cases, you'll be very amazed, depending on your level of what you think is privacy, to see some of the things that people talk about on the Facebook and in other social networking venues where they have the opportunity to say things they feel it's semi private, but on the other hand, they are realizing that there's the vast nature of it's being broadcast across the internet. And fortunately for most of us, or unfortunately for some, you can give up your privacy at any time in a number of different ways. And we're going to discuss some of those ways as I go along. Now you might be asking yourself about this point, about this time, is what does this have to do with genealogy? And the answer is we deal in information about people. We are constantly asking for more and more information about our ancestors. We're discovering that information through a variety of research techniques. And there's a fine line between finding out everything you know about your parents and your grandparents and what you yourself, what other people may be able to discover about you yourself. And so these are things that we think about when we're involved in genealogy. So we get a whole lot of different perspectives on genealogy, on privacy, particularly in the context of genealogy. I have a perspective that comes from a certain my certain background. My background, first of all, when I was very young in small town. Secondly, being involved in close social organizations. And more importantly than that, after 39 years of being a trial attorney and also an intelligence analyst for the United States Army, and in the fact that I'm overwhelmingly involved in online discourse and social networking, all of those give me a perspective that probably is not shared by too many people, percentage-wise, even in my own community. So from this standpoint, there is a legal perspective to privacy. What is and what is not considered to be private by the legal community, including judges, juries, courts, and attorneys, and others who are involved. And secondly, there are personal perspectives on privacy, what we could consider as part of our private lives, the things that we do, which we would be extremely disturbed if other people were able to learn about or witness. And then in the third position is what we call our practical perspective, and that is what is practically available for us to be private about. And in order to have sort of a comfortable way of dealing with genealogy as a whole and putting up online quite a bit of information about various people, we really do have to have a developed practical sense of what is and what is not subject to privacy. Well, first of all, I'm going to talk about the legal right to privacy, as to whether or not we have any legal protection. Our society does not really recognize the concepts of personal privacy that we all kind of assume when we're talking about what we consider to be socially, culturally acceptable. That's not been codified or included in our legal system. Actually, the right of privacy, as we call it in a legal sense, was originated in a Harvard Law Review article back in 1890 by Samuel D. Warren and Louis D. Brandeis, and Brandeis became a Supreme Court justice. So his concepts were, even if they were developed before he became a justice of the Supreme Court, he was very persuasive in establishing certain new or innovative legal principles. And his right of privacy that he talked about back in 1890 was really innovative. Before that time, the idea and the concept that the government or any kind of a legal representatives would be involved in anything we would consider to be privacy was not well accepted, or had really not been explored. And interestingly enough, there is no statutory, meaning there's no laws that have been passed or common law right to privacy. So before 1890, there was simply nothing that existed in either the common law or statutory law that would confer a right to privacy as it's expressed by Brandeis and Warren in their article. And to some extent, the concepts that we have today about legal concepts of privacy are derived from the laws of libel and slander, both of which today are usually called defamation, sort of jointly. Obviously, libel is written and slander is spoken, but we've kind of avoided that distinction anymore, and there are both causes of action that were previously available are now called defamation. So what we've said about privacy has been colored by the extreme, where someone says something that is untrue or so outrageous that it is actionable under our court system. Now, if you have a hard time with privacy, in other words, you are worried about it, it's something that you're concerned about, it's something that you're not comfortable with, you cannot reconcile in your mind the boundaries that may exist between privacy and what is allowable in genealogy and many other parts of your life outside of just talking about genealogy, then the answer is so does everyone else and the courts. So nobody has a real clear idea, and there's no clear distinctions about what is and what is not private. And it's always in a state of flux, and it's always in a state of what I would call disarray from this standpoint. Now, it's important to understand some things that are not private. Okay, so let's get into the not private area. Perhaps understanding some of these things that are not private will help us to clarify what is and what can be considered private. And this is more important. Some of these things bear directly on the issues of that we've raised, that are raised in the genealogical community. First and foremost, social security numbers. There's this huge thing about social security numbers. Some people will refuse to give you their social security number because you should maintain that as private. And where this has originated, where this problem has originated, is with this concept of a thing called identity theft, where someone's going to steal your identity, and social security numbers have been identified as the key component of stealing somebody's identity, and all sorts of, even federal laws are being considered, making it more difficult to, or more detrimental to steal somebody's identity through using a social security number or whatever. Well, first of all, why aren't social security numbers private? Well, because they aren't. They're public numbers. They're numbers that are given to you by the United States government, and they're recorded in the United States government. What do you have to use it for? You have to use your social security number to get social security benefits. So if you want to, if you want to participate in the United States Social Security program, you have to give all sorts of people your social security number. You have to, every time you get a job, you have to give them their social security number. You may have to give a social security number to your doctor. If you want to deduct doctor bills, you may have to give social security number to your school. If you want to get registered into a school, you have to have a social security. Children usually have to have a social security number in our society to get into grade school, to get into kindergarten, even to get into daycare. They might have to have a social security number. So I don't know where they get the idea that the social security numbers are somehow private. In my lifetime, my social security number has been used for very public purposes. It was my military ID number, and it was also my student identification number. So for many years, they were used universally for all sorts of purposes. The idea of identity theft is a completely different issue. I've written blog posts on identity theft over the years, constantly pointing out that it may or may not be as big a problem as most people understand. One of the biggest issues is the definition of what is and what is not identity theft. And it turns out that identity theft is more concerned about credit card transactions than anything else. In other words, what they're considering to be identity theft is if you lose your credit card, that's something that goes into the category of a identity theft issue. Or if someone uses your credit card number without your permission, that then becomes an identity theft issue. So we really, what we've got here is a society that is unable to come to grips with a technology of credit cards and use them in a way by which they can't be used improperly. Right now, we're up to the point where we've embedded chips in some of the cards in the United States, some of the credit cards, and it's mandatory. Have almost a year now that they've made it mandatory for transactions to be made with the chip, and yet there's still many institutions that will not, that do not have or have not yet to implement using even chip technology, much less any other what they call biometrics, which are everything from facial recognition to fingerprints to retina scans and things you see in the movies and you may have experienced if you've gone into high security areas. But there's ways to cut down on credit card fraud, but the commercial enterprises have not been willing to take those steps. Your address. I really do get people who think their addresses are private, and I'm wondering where they live, because if I drive by their house, I can see their address. There's kind of this is where you start to get into this unreality of the whole issue of privacy. Because people are so concerned about identity theft that they don't even think that they can put their name and address down on a some kind of an application or form because they're afraid somebody's going to steal that information. Another one out there, telephone numbers. Telephone numbers can hardly be considered to be private. Here's the situation is you're going to have to understand that the difference between what we call privacy in the public sector and privacy in your private sector, individual privacy. That's what I was getting at earlier in this presentation. Because a telephone number is a way to communicate, and guess who knows it? The telephone company. You have to provide them with information. Are you think that that's private? That it's private because the telephone company and anybody who knows has access to that is private. Here's a good analogy. You walk into a doctor's office to have an examination in our society today, and 9 times out of 10, they're going to give you this long piece of paper to fill out while you're sitting there in the waiting room, which will ask all sorts of questions, including how you're going to pay for the services that you're going to require as from the doctor. And they will not only ask you for your credit card, but they will also ask you for your telephone number and your address. And so the little the clerk or the nurse or the office worker that's sitting there, you don't believe they have access to all those numbers and all of that information. This is it's kind of silly when you start thinking about who actually can get this. Of course, today we have this vast area of social networking sites, and we have some people who in the genealogical community have been paranoid about putting up any information on an online family tree because they were afraid that they didn't want their grandchildren's names to be made public. And yet every day I watch people put up pictures of their kids and doing cute little things, or be involved in things that sometimes aren't quite so cute on social networking websites. If these people aren't concerned about their children, why are their grandparents concerned about putting their names on a family group record? It's kind of an interesting disparity between the way that the people think. Here's some more things that are not private. Genealogy. Genealogy is something you discover from historical records. It is not private. The reason why some records are not available to examine are very, very complex and have more to do with control by governments than they do with any real concern about the what we call privacy of the people involved. But the main rule here in genealogy is that it just really doesn't deal with anything that we would consider to be private. And there's a situation here because people think that is the case. This is being more specific than just genealogy in general, but family trees or pedigrees, they're not private. That's not private information. If I were really interested in finding out who your parents, grandparents, and great-grandparents and everything were, I can do research. I can find out the information about you or any member of your family, primarily of deceased people. I may have a slight difficulty in finding out information about living people. But unless someone has taken some absolutely extraordinary efforts to conceal their identity or to change their identity or to, in effect, disappear off the face of the earth, then they are very discoverable. Another thing that aren't private are most U.S. government records. We'll talk about that more in just a minute. I'm not going to go into it right now. Okay, so let's not confuse individual privacy with copyright claims. Unfortunately, this is an area where people begin to think that when they write something, that what they write is private. That what I have in my family history is private to me, and I would feel like I was violated or some problem occurred because somebody knew about it. Well, where we stop with that is that we have what's called a claim for copyright. Copyright says that that you have a private right of action if someone copies your personal work as the author or the originator of a particular document. That doesn't have anything to do with your privacy. It has to do with what is defined as copyright in the statutes of the country where that particular work was created, whether it be the United States or England or Germany or wherever else in the world. And they each have their own separate, different copyright laws. What's government security is often claimed to be something that has something to do with privacy. There's been a big thing lately where different computer groups who are collectively known as hackers have hacked into various databases, generally speaking for commercial gain. In other words, they're trying to steal information so they can sell it and make money. But on the other hand, there are some who, with whatever motivation, hack into government records and then use that information for political purposes. And we've had some very large, in fact, this last presidential election was colored by a constant stream of information that was being supplied by third parties from so-called private government or classified government information. So the government uses a different word than privacy. They use the word classified, and but a breach of privacy, as we're talking about it here, it doesn't really involve that government security issue at all. It's a whole different subject there. And another thing is that many documents can be restricted due to commercial interests such as trade secrets. Those things are sometimes considered to be private or private property. The term privacy is a pretty slippery term, and particularly when you get into issues such as this with commercial interests and restrictions. Confidential information. If I tell you something in confidence, and you disclose that, is that a breach of my privacy? Well, it would depend, of course, on the subject matter and whether or not I considered what I told you in confidence was private. But in a sense, confidentiality does not necessarily imply that the information that is held confidential is in any way private. I was often subject to receiving confidential information as a member of the United States military. Many times I was told things that were in secret and even beyond secret in their impact, and yet none of that would I consider to have anything to do with my individual privacy or the privacy of any other individuals. Okay, so we do have something in the United States called the United States Privacy Act, and it was a Privacy Act of 1974, and that was basically the first point that should be emphasized here is it doesn't deal with anything that most people would think of as private. It's not a Privacy Act dealing with what you consider to be private and what you don't consider to be private. It is basically here, it's called the Privacy Act of 1974. It's found at 5 United States Code, that's USC as United States Code at section 552A. And what it does is it's established as a code of fair information practices that govern the collection, maintenance, and use and dissemination of information about individuals that's maintained in systems of records by federal agencies. Okay, so this is basically an act that tells the government what they can and cannot learn and store and maintain about you as an individual. And so that is far different than what you may consider to be private. So now there's two different kinds of things. We have what's called the Privacy Acts, that Privacy Act, and we have another thing called the Freedom of Information Act, or FOIA. The Freedom of Information Act and the Privacy Act have certain exemptions. So they have specific exemptions from disclosures dealing with classified or restricted documents. So even though they protect certain types of information in the federal government, there's some of the information that has to be disclosed anyway, and even if they figure it's classified or anything else. In other words, what the Freedom of Information Act has, and certain parts of the Privacy Act, which allow people to go to court and actually force the federal government to disclose information, particularly about the individual themselves, but that's Privacy Act issues. But the Freedom of Information Act is basically a way to force the government to disclose any and all information that has to do with a certain subjects. So these are important exemptions to the Privacy Act and the Freedom of Information Act. And they need to be reminded over and over again that neither of these acts have anything to do with individuals or individual what they think or what they don't think is private. They deal with government documents only, U.S. government documents only. Some of the states, by the way, have their own Freedom of Information Acts, or Sunshine Acts, sometimes they're called. Basically, there are actions that can be taken by individuals to force the government to disclose certain documents, even if they do not wish to do so. So as I've said, both of these acts address issues of the availability of government records to individuals and organizations. And there are some, for instance, there are law firms out there that their primary area of practice is filing Freedom of Information Acts actions against the federal government to obtain records that they feel are and should have been disclosed to the public. So we need to understand that any act that's done in public is by definition not private. And so if you are a public figure, that means that the actions that you do are in the public view, and so very little, if any, of what you do could be considered to be private. So it's I think we get this where we get most of our impressions and most of our information about this whole subject is from the people who are involved in the entertainment industry, who are always revealing some gross or inappropriate detail about their lives or their relationships with others, and yet are constantly aghast because they feel like their privacy has been violated by the press or by somebody or whatever. So is there a right of privacy? Do we have anything out there that we would call a right of privacy? Okay, and we might want to know that the United States Constitution or any of its amendments do not mention privacy at all. It's not even a word that has been used in conjunction with the constitutional law. Now, if we jump across the ocean to the United Kingdom, we find a completely different area. We find that the United Kingdom has actually imposed what they call the Data Protection Act of 1998, and it contains specific language about privacy. Now, this does not exist in the United States, but it does exist in the United Kingdom. And as far as the courts are concerned, if there are any provisions about privacy, then those provisions are strictly construed by the court. What does that mean? It means that the judges and juries are going to be instructed by the law that says about privacy, that if you are claiming that something is an invasion or was detrimental to your privacy, then you have to be able to prove that by a very strict adherence, or as it said here, strictly construed, meaning the courts interpret the laws very, very narrowly. They do not include very many actions or very many rights within that area of the law. So now here's where one of these issues arises continually. This is the Fourth Amendment. It's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it says they shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Well, this is the historical point that was created as an amendment to the Constitution that was trying to define what steps the government could take to discover information or to find things that might incriminate somebody based on searches and seizures. Now, this search and seizure law is very much integrated into the overall criminal law in the United States of America. But understanding that the laws of searches and seizures have nothing at all to do, or they're not based on privacy concerns. It's not because you think that your trunk of your car is private that the government has to get a warrant to get it opened. It's basically because there are some procedural laws that have been implemented in light of constitutional amendments. So these are based on the Fourth Amendment to the Constitution, laws of search and seizure, and the legal restrictions, and they're primarily legal restrictions on the police or other authorities who suspect that a crime has been committed and whether or not they can search a person's property and confiscate any relevant evidence to the crime. So, used in that context of searches and seizures, we hear a term out there that's used that someone would have a reasonable expectation of privacy. Now, this particular term is used strictly as a legal term in the context of cases challenging the actions of the governmental authorities, or the actions of governmental authorities attempting to be expanded beyond the more what would be mostly expected. So this particular term really has nothing to do with privacy in the sense that we might think. So you might hear people say, well, I had a reasonable expectancy of privacy when that happened. And the answer is, yeah, you really are talking about something that's being defined by case law in the United States up to the Supreme Court. And whether or not you do or do not have a reasonable expectation of privacy really has nothing to do or corresponds at all, does not correspond at all to anything that you might consider to be private as opposed to public. So this is often confused with what we call privacy per se, or privacy alone, meaning that what we consider and what we are expecting as private is not the same thing as is being discussed by the courts when they're talking about searches and seizures and whether or not a person had a reasonable expectation of privacy. Let me give at least one example, because otherwise it might be entirely too confusing. One of the questions that comes up perennially in the courts is this question of searches for drugs in the context of automobiles. And the question has been now defined to the point where if an officer has a reasonable suspicion to believe that drugs are present, and that is, they can smell them or they can see them lying open inside of an unenclosed, not inside of a box or anything else in a motor vehicle, then they have what's called they've crossed a basic threshold and are able to stop the person and conduct a search. The alternative to that is that they would be required to go get what's called a search warrant. They would have to go before a judicial officer of the court and provide some testimony as to why they would need the judge to order certain information to be made available to the police. So this is where you start to get into the questions of reasonable expectation of privacy. Did a person, when they put something in the trunk of their car, have a reasonable expectation of privacy that would preclude a government official from searching the trunk of the car without a search warrant? So those are the kinds of complicated things that we get into. So this is basically a measure of whether or not a search is reasonable by a law enforcement officer. Now, here's the basic rule that affects everything that we have to do with genealogy, and that is dead people have no privacy, period. No privacy. In other words, the fact that your great-grandmother had an illegitimate child, or that your great-great-grandfather was put in prison, or that your great-grandmother was crazy and or mentally infirm and was put into an institution, all of those things are historical facts and are discoverable by anybody who wants to make the effort to go out there and discover that information. Now, if you come from what I call the thumper business of privacy, and that is what Thumper had to say in Bambi, the movie by Walt Disney, is that if you can't say something nice, don't say anything at all. I think that's very, very difficult to carry over into genealogy, because we're always discovering that people had a lot of problems and a lot of things that we would consider to be socially and perhaps even criminally terrible items, even though but that's part of our history. That's part of what genealogy is about, is discovering all that information. Doesn't have really anything to do with privacy at all. So now we're in a situation where we have genealogy as it is opposed to privacy. So what are the concerns that we have to go through in order for this to work properly? Number one, my rule would be this: just avoid entering information about living people and making it public disclosure. Now, if you're entering information to your own computer program on your own computer or into your own written documents, then I don't see any reason not to keep that information. Of course, you would like to know the birth dates of your children and grandchildren. You would like to know the, perhaps anniversaries and things like that. And although some of that information you might consider to be private, it's just not a good idea to put anything to place out there in the world. For example, one thing that happens when you sign up for Facebook, the first thing that's going to happen is they're going to ask you to put in your birth date. If you put in your birth date in Facebook, on your birthday, you're going to get, depending on how many Facebook friends you have, you may get dozens of, if not hundreds of congratulations about your birthday from people you've never heard of and you've never had any contact with. Okay, well, that's the problem that we're talking about here. And this was pretty simple. Don't include any information you consider private. Now, if you consider everything about your dead ancestors to be private, then you're simply mistaken. You have no concept of what the actual term privacy means or who it applies to. But if you have any information about yourself or any other living person, then that you consider to be private, then I would consider that I would suggest that is not appropriate to be included in an online program. Also, offensive does not include equal private. Simply because I find out something that's really, really offensive and really, really bad about you or your family does not mean that any information that's contained in that is private information. This is particularly true if I got it from a public source. Sometimes when I'm dealing with some kinds of organizations, occasionally they will say, "Well, I'm going to tell you something, but I don't want you to say anything because it's going to be private between us." And I say, "Well, that's fine, and I'd be glad to maintain that degree of trust and not disclose anything that you have told me that you consider to be private or not for full daytime disclosure online. But I'll tell you where the line draws. If you put it online, then it no longer is private, and I'm more than willing." So let's suppose that a software developer tells me that this is a new innovation that they're going to put in their program. Well, I'll never say anything about that. I mean, it's just a matter of course. But if they happen to put it online and I can discover it by going online to discover that information, it is by definition no longer private. And I feel like it's kind of an open field at that point. Here's the real difficulty. The real difficulty with genealogy is navigating the shoals of what other people think is private. It's not what you think is private that's the big deal. It's what other people think is private. And the problem you have with genealogy is you're constantly in the status of trying to second guess what somebody else thinks. So you get into the point where you say, "Well, I don't know if I want to put up the fact that great aunt Marion was an illegitimate child. Maybe she doesn't even know that yet, and maybe there's some information that shouldn't be disclosed." Well, we're back to the issue that I said just recently, a few minutes ago, and that is, if you think it's private, don't disclose it. Don't put it in a family tree, and don't put it online. So, this is not the kind of thing you want to put in. But you also need to recognize that you're not out there to rewrite history. Um, Too many people are involved in that. Genealogists should not be involved in that, and that is that we don't want to sugarcoat and clean up all of the dirty laundry that we may have out there in our families. Okay, for example, here's some of the things that I think, as far as genealogy is concerned, should not be considered to be private issues. And that is illegitimate children. Unfortunate, but sometimes we can actually identify who the non-complaining or the complaining person, the non-complaining person being the other party to this illegitimate child situation, who they are, and even disclosing the fact of an illegitimate child is sometimes coming up as a problem in genealogy. That's kind of comes with the territory, and you're not going to sit there and pretend that it doesn't exist. I've got those situations going on in my own family where we have situations that are fairly obvious that there was an illegitimate child or something of that nature, and yet even into the second and third generation, there are still people who won't talk about it. The fact that you have criminals in your ancestry is also something we don't have to worry about being private. These people don't have any privacy, and you shouldn't have any concern about identifying them if their criminal behavior. I guess if you'd like to feel better about it, you could always say, well, what they did would not be a crime today. Well, that may be true, but they did end up in jail. Bankruptcies are also an area where these are matters of public record. They're published in newspapers, all sorts of things. Trying to keep a bankruptcy private, that doesn't work. There's no such thing. Abuse, this is a little bit closer to home as far as people who feel the effects or the problems that are associated with abuse. And the question is, are you going to not talk about it among your ancestors, that you learned that your uncle was abused by his parent, by your great-grandparents or something? These are not things that need to be read about in the genealogy. You think, But my point would be that you don't just rewrite history. You don't just sit there and say, well, that's really a bad thing, and so I don't think we need to include that in there. Addictions, another problem. Mixed race marriages. Everyone in genealogy seems to be really anxious to find out that they had Native American ancestors, but they were not so happy about the idea that somebody was involved in an interracial marriage. I don't think we can pick and choose as genealogists what we would want, what our subjective uh, levels of propriety are, as opposed to what other people may believe or what they think. All of these show up in family histories. There's probably not a family history out there that goes past a few generations that does not involve at least some of these or all of these different types of problems. So once again, to repeat, don't rewrite history to appease your own personal prejudice. Just because you think that an interracial marriage is a terrible thing does not mean that you write it out of history. And just because you believe that people were morally wrong for having an illegitimate child does not mean that you don't recognize the fact that the child had a parent and may have been related to you. Now this brings up another issue, and the question could be asked, and if you've thought about it, is why do you think Facebook and Instagram are free? And the answer to this is very simple, is this, and this is a quote that I bring up here. In our worldwide society today, information, and particularly detailed information about individual people, has become a commodity to be bought and sold. So the information we voluntarily and perhaps unknowingly share online has become the way the so-called free websites, including Google, Microsoft, and all the social networking sites, are supported. So how do you think that Google makes money, or how do you think that Facebook makes money? They make money through advertising, and they make money through advertising by disclosing the information that they have gathered about their users. Every search made on Google and every search made on Facebook has been recorded, and all of your personal preferences and all of the items that you think are important are all recorded and available to anyone who wants to search for them online. So if we recognize that personal information is a commodity, then we can really get down to the point of what we want to consider to be put online and what we don't want to consider to be put online. Now, strictly from a very skeptical or different way of looking at genealogy, understand that the information that you supply into a family tree is essentially becomes the commodity that's being sold by the larger genealogical websites that are commercially based. So as you put up your information, then that information becomes instantly monetized, and you are then a part of that commercial process. So family trees are the commodity. That's exactly what their product is, the family trees, and they are selling your product. You provide that to them free, and then they sell it. That's how it works. But if we look at it, the arrangement's still mutually beneficial. You are benefiting having a place to store your information. You have a place to do research and find additional information, and that because that is the case, you are willing to give up the small amount of privacy that may be involved in putting your family tree online. Now, this is going to become as a shock to some, but genealogy is really, really small potatoes in the online world. Now, how small potatoes, do you want to know? Well, let me give you an idea. We mention constantly in the context of these webinars that the webinars are being recorded and put on the BYU Family History Library YouTube channel. Well, do you know how many views that the largest online or the most popular YouTube channels have? How many followers they have? There's a comedy site online that I was talking about to one of my coworkers here, and they were pointing out to me that they had over 4 million subscribers and had into the billions of views. And that certain individual is smiling now that he remembers that he told me that. If you want to look at the number of views on even the largest of the websites, of the biggest names in genealogy, if you will, and compare those to somebody who has put up a picture of their cat throwing up on the carpet or something, then you'll begin to understand how small potatoes that genealogy is in the real world of a real online world. Okay. So here we are to the last issue, and that is what about DNA testing? Well, that's more private, personal information about you that no one would have any possible way of obtaining without your permission and without you broadcasting it to the world. And they are more than willing to let you pay for the privilege of having you disclose to them your DNA information so that they can use it to build their business. Okay, so that's if you want the real critical view of how the whole thing works. That's how it all works. But you pay them, they send you a test kit, you send them the information that they need in order to build their family tree and provide you with even more information. And there's a trade-off there. But that's what the DNA testing is doing. So if you publish your test results on a family tree, how can you claim that anything you've done to that point is private? I mean, you've just told them your DNA, folks. So I'm not so concerned about privacy as I am about people who are disturbed about privacy, actually. I think we have a bigger problem with people who get paranoid about it and become overly concerned. So if you really want to have an interesting insight into what happens with your DNA testing, read the terms and conditions of the family tree website that you just contracted with. So if you want to see what they can do, because they have an absolute right to make it public, folks. And what we really are going to, what I'm really saying here is that under the current conditions of our world and the way that our technology is going, there's really not much left out there of what we consider to be private. And is it something you should be concerned about? There's some aspects of it that you need to be concerned about, obviously, but on the other hand, those aspects, those things that we're concerned about when we do genealogical research and we put our information into a family tree online about our ancestors, certainly has nothing to do with our individual privacy. Of course, there are people out there who will argue and say, well, if you put your name up there, they're going to be able to hack into it and get all that information. And my answer is, nobody has to hack anything to get my name and my address. I'm sitting right here in Provo, and you could drive down the street or follow me home or do all sorts of things and find out my name and my address. So I don't think that's something that is persuasive to me as being an issue in privacy. So what is there left about your life that you think is private? So I think that maybe is the real question we need to really kind of ask ourselves and wondering. The last one here is, what about your medical records? You think those are private? You know, you have these HIPAA and HEPA and all this kind of stuff from the doctors about how we can't disclose this. We can't tell your wife or your husband what their spouse's medical records say without their express permission and all this kind of stuff. Why do you think that all exists? Has that got to do with privacy? And the answer is, well, there's kind of an arguable term used for privacy in there, but it's really has a lot more to do with some other issues in our society that have nothing to do with with privacy per se. They have to do with social structure and stigmas that have been placed on various diseases and various types of things that people can't. If you have a disease, a communicable disease that is bad enough, you can lose your job, you can be kicked out of school, you can be ostracized by society. And that's more of the issue than anything that has to do with what they're calling privacy here. What if you pay for a prescription? Let me give you an example here of what happens if you pay for a prescription. You go into, you get a prescription from your doctor, and you're saying, oh, what I take as my drugs that I take are private. So where do you go to get your prescription? Walmart. And you hand it to some clerk who you've never met and never had anything to deal with. And then you hand him a credit card to pay for it. Tell me about how private that is. That's not privacy. So when you hand that credit card to somebody, you have just made a record in a lot of different places, not just in Walmart, but in a bank, and it's available out there on the world as to that fact that you just purchased a prescription, a specific prescription. So what do we do about all this? What are we concerned about? We're to the extent where we're going to become paranoid, go live in caves and never have credit cards or cell phones or do anything, and we're going to just kind of retreat into our shell. The answer is we live in a communal society. We have a lot of shared information between us. There are some things that are better not talked about and better not disclosed and discussed. But on the other hand, becoming paranoid or fearful of what's happening in this society is just some of the things that we're cautious about. There's some things that we don't do, and there's other things that we do. But as far as it's concerned with genealogy, there really isn't any of these concerns. There's nothing we're doing out there with genealogy that's going to increase any of our risks or lose any of our privacy. And what I like to say at the end here is worrying about privacy and genealogy is like locking the barn door after the horses have gotten out. I mean, you're already out there, folks. Everybody's out there. And you can obtain just about any kind of information you want to about any kind of person out there if you want to pay a fee for it. And genealogy is only a very, very, very small, insignificant part of this total issue. Okay, thanks for watching. This has been another BYU Family History Library webinar, and remind you that the webinars are recorded on our YouTube channel. Thank you.
Thank you, James, for the wonderful webinar and for everything that you've done for us. Thank you for joining us today and participating in this webinar. If you didn't get a chance beforehand to answer some of the questions we have at the bottom, feel free to do so now, and also give us some feedback about what you thought about today's webinar and how we can improve our webinar series going forward. If there are any remaining questions, feel free to write those in and we'll make sure those get answered. And make sure you just keep an eye on our website to see when our January schedule is posted so you can join us for the next month in the coming year. And again, wish everyone a Merry Christmas and a Happy New Year.